The sound that changed the hearing was not the judge clearing his throat. It was the zipper. A prosecutor standing 3 tables away pulled open a white, insulated pharmacy tote right there in federal court, and every person in the room understood almost instantly that the hearing was no longer about extra time before sentencing. By the time the zipper stopped moving, Dr. Mara Ellison's lawyer had stopped taking notes. The judge was asking questions he had not planned to ask, and Mara was staring at that tote like it had become something radioactive. She had walked in expecting a delay. She left through the marshal's door in handcuffs. What made the white tote lethal was not just the bag itself. It was what the government tied to it in the next 10 minutes. A missing set of retained oncology samples, a loading dock audio clip from after midnight, and one instruction Mara could not explain away once the judge heard it in her own voice. The tote looked like ordinary clinic equipment. Cheap vinyl, gray zipper, printed temperature patch on the side, but it connected movement, concealment, and intent in a way the defense could not survive. Mara Ellison was 46 years old, founder and medical director of BrightPath Infusion Group, a fast-growing cancer treatment network with clinics across 3 states. In public, she sold herself as the efficient face of modern infusion care, the doctor-administrator who said she could cut cost and waste without touching patient safety. The government told the jury a much darker story. Prosecutors said BrightPath systematically underfilled high-cost infusion bags, billed federal programs for full-strength doses, and diverted the shaved-off drug volume into off-book inventory later resold through affiliated purchasing channels. 3 days earlier, a jury convicted her on healthcare fraud, wire fraud, conspiracy, and adulterated drug counts. That afternoon, her lawyer only wanted more time before sentencing. The request was supposed to be dry. Her attorney, Colin Mercer, framed it exactly that way. The record was large. Probation needed time. Experts were still reviewing the medical loss calculations. Mara had complied with release conditions for months. She appeared in a navy suit with a cream blouse. No jewelry except a wedding band, and the kind of expression some white-collar defendants practice very carefully after conviction. Not cheerful. Not broken. Just composed enough to suggest the room still owed them procedure. Then Assistant U.S. Attorney Lena Park stood up and said, "Before the court reaches scheduling, the government moves for immediate remand." That sentence snapped the hearing into a different shape. Mercer turned toward Mara so quickly his chair legs scraped the floor. Mara did not move at first. But the look on her face changed. Not panic. Recognition. The kind of recognition people get when they realize the government found the thing they were hoping would stay buried just a little longer. Park asked to mark Government Exhibit 118. The courtroom deputy handed her the white pharmacy tote in a clear evidence bag. She unsealed it, placed it on the lectern, and rotated it so the judge could see the side panel. Printed there in faded blue letters were the words BrightPath, Cold Shane. Underneath the logo was a handwritten label strip. QA retains, do not discard. That should have been enough to make the defense nervous. It was not the whole problem. Park told Judge Sloan that the tote had been recovered 36 hours earlier from a refrigerated holding cage behind Northeast Sterile Waste Services, a medical disposal contractor in Elizabeth, Cantrell. The date mattered because BrightPath had already been under a preservation order covering medication logs, retention samples, compounding records, and any physical materials tied to the diluted lot allegations. The government's position was simple. Somebody removed protected evidence from BrightPath's quality control freezer and sent it toward destruction. Mercer objected immediately. He said no foundation had been laid. No witness had tied the tote to Mara personally, and the government was attempting to convert a chain of custody dispute into a bond issue because it did not like the optics of waiting for sentencing. Judge Sloan asked Park the obvious question. "How does this tote get to Dr. Ellison?" Park answered in short steps. First, the exterior barcode sticker. The tote's internal asset code matched BrightPath's inventory system and showed the bag had been checked out from the company's Newark compounding suite at 11:18 p.m. on October 6th. Second, building access. Mara's executive access card opened the quality control freezer room at 11:11 and the loading dock corridor at 11:24. Third, parking footage. Her black Range Rover entered the employee garage at 10:57 and exited at 11:39. Up to that point, Mara still looked like someone telling herself there might be room for explanation. Maybe the card was borrowed. Maybe the bag was moved for innocent reasons. Maybe the government had one suspicious object and not much else. Then Park opened the tote. Inside were 6 empty specimen sleeves, each with adhesive residue where tamper labels had been peeled away. There was also a small digital temperature logger the size of a thumb drive, still blinking red because its battery had not fully died. Park placed the logger under the document camera. The screen showed a cold storage trip beginning in Newark at 11:19 p.m., a door-open spike at 11:31, then a temperature climb consistent with the bag sitting outside refrigeration during transport. At 12:06 a.m., the logger registered another prolonged door opening at Northeast Sterile Waste Services. The record ended at 12,017. That alone was damaging. The next piece was worse. Park told the court those 6 empty sleeves were supposed to contain retained sample bags from 6 chemotherapy lots already central to the trial. In compounding pharmacies and infusion networks, retained samples are not decorative paperwork. They are the physical backup. If a later question arises about dilution, contamination, or preparation integrity, those retained bags are where the truth lives. According to the government, BrightPath's retained samples from the most disputed lots disappeared after conviction and turned up as empty packaging inside a tote marked "Do Not Discard." Mercer was on his feet again. He said the government was skipping over crucial possibilities. The samples could have been pulled for lawful internal review. Sleeves could remain after ordinary testing. Empty packaging did not prove destruction of evidentiary contents. He reminded the court that medical organizations move materials constantly and that the government was relying on timing to create drama. Park said, "Timing is not the government's strongest point." Then she asked permission to play a recording. This is where the room got tighter. The audio did not come from a wiretap. It came from BrightPath's own loading dock security system, one of those cheap industrial cameras with weak video, but surprisingly good sound when nobody remembers the microphone exists. Park cued the clip to 11,027 p.m. There was a burst of static, the hum of refrigeration units, the squeak of dock wheels, and then Mara's voice. Not ambiguous, not partial. "Mara, use the white tote, not the blue couriers. No chain forms on this one." The clip paused. Mercer said context mattered. The court agreed to hear more. Park played the next 17 seconds. "Mara again. Pull the QA retains from freezer 2. Only the challenged lots. If those lab people want samples later, they can test the production set." Then a second voice, male, likely an employee. "Do you want waste stickers?" "Mara, no. I want it clean." No sound in federal court is louder than silence after a bad recording. Judge Sloan leaned back, not dramatically, just enough to show he was no longer hearing this as an ordinary continuance request. Mara's face had lost color around the mouth. Mercer had stopped objecting for a second, which is usually how you know the defense is recalculating in real time. That should have ended it. It did not. Park moved to the next exhibit. A one-page lab discrepancy report generated the following morning. 6 retained sample entries marked missing. Same lot numbers as the empty sleeves. Same freezer location mentioned on the audio. Same initials on the QC sign-out field, ME. Mercer tried to slow the descent. He said initials could be copied. Employees follow the instructions of executives all the time, without the executive knowing what the final paperwork will look like. Even if Mara had authorized sample movement, he argued, movement was not destruction. Park agreed. Then she made it worse. She said the government was not arguing mere movement. It was arguing purposeful substitution. She placed 2 photographs, side by side under the document camera. On the left were the missing retained lot entries from BrightPath's internal system. On the right were 6 substitute bags found in the same freezer shelf the next morning, now labeled as if they were original. Retains. The problem was visible even without a chemistry degree. The handwriting on the replacement labels was newer, darker, and all 6 labels used the same fresh marker stroke. The timestamps embedded in the adhesive printer codes showed they had been generated at 6014 AMU, hours after the tote left the building. If that were not enough, Park called a witness, not for trial, for detention. Nadia Romero, a former quality assurance pharmacist at BrightPath, took the stand looking like she had slept very little and regretted even less. She testified that retained bags were never supposed to leave the monitored freezer without chain forms and dual signatures. She said the white tote was used only for internal emergency transfers. She said freezer 2 contained the lots that outside labs most wanted because those were the bags whose retained concentrations ran lower than the final record suggested. Mercer objected to hearsay, characterization, and overreach. Judge Sloan overruled him for detention purposes. Then Park asked Romero the one question that made the tote even more poisonous. Had Dr. Ellison ever previously told you to use the white tote without chain paperwork? Romero answered, only when she wanted something moved quietly. That line landed hard. Mercer attacked her credibility. Former employee, angry departure, cooperation motive. He asked whether Romero had been promised anything. She said no. He asked whether she disliked Mara personally. Romero said that was irrelevant and that she was there because cancer patients had been treated with drugs that were not what the records said they were. That answer did not help the defense either. Now Park turned back to Mara herself. Dr. Ellison, the judge said before anyone else could speak, did you authorize removal of retained oncology samples on the night of October 6th? Mercer asked to answer for his client. Sloan said no. Mara stood slowly. She said BrightPath had multiple categories of stored material, legal retains, internal training material, shelf life controls, and old duplicative holds. She said late-night movement could reflect preparation for expert review, spoilage, separation, or ordinary cold chain management after a chaotic trial week. She said the audio captured fragments, not intent. Careful answer, not clean. Sloan asked the next question. Then why say no chain forms? That was the one she could not meet head-on. Mara looked at Mercer. Mercer looked down at his file. Mara said chain forms create confusion when material is being reorganized internally, and that she may have been trying to prevent duplicate paperwork during a rushed review. The judge didn't interrupt. He just let the answer sit there long enough to reveal how weak it was. Park stood again. She said the government had one more item. It was an email printed at 12:41 a.m., sent from Mara's phone to BrightPath's operations chief. Subject line, sample issue. Body. Make sure freezer 2 shows substitute retains before audit team returns. Same labels as before. No notes. Mercer objected before Park finished reading. He said the email did not use the words destroy, conceal, or replace in any criminal sense. He said substitute retains could refer to training controls. He said the government was forcing sinister meaning onto technical language because it knew the phrase sounded bad to outsiders. Park answered with the shortest sentence of the afternoon. The outsider is the court. Then she added one final brick to the wall. The substitute bags had already been tested by the government's lab. They were not retained chemotherapy samples at all. They were sterile saline with trace residue brushed onto the ports, enough to make them look handled, not enough to match the disputed drug concentrations from the original production lots. That meant somebody had not simply moved evidence. Somebody had tried to leave behind a fake version. From that point on, Mara's release was living on borrowed time. Mercer made his last full argument. Mara had complied for months. She had not fled. She had surrendered travel documents. She was a physician, a mother, and a nonviolent defendant. Immediate detention, he said, would be punitive. What the government described could still be sorting mistakes made in a panicked corporate environment after a devastating verdict. Park did not overtalk her rebuttal. She did not need to. She said a convicted defendant who uses her own access card to open evidence storage after hours, instructs staff to bypass chain documentation, removes challenge retained samples, and orders substitute materials placed before an audit cannot ask the court to continue trusting her with freedom. Then came the key question. Judge Sloan leaned forward and asked Mara, very quietly, what did you mean by, I want it clean? If you spend enough time in court, you learn that the quiet questions are usually the dangerous ones. Mara tried to answer fast. She said she meant orderly. Neat. Administrative. She said she did not want a cluttered transfer that could risk temperature exposure or mistaken inventory entries. Sloan asked, then why remove the challenge lots and not the others? Mara swallowed. Said those were the ones under immediate expert discussion. Sloan asked, and why replace them before the audit team returned? There it was. The answer never came cleanly. She said the audit team often misunderstood technical holds. She said substitute materials could preserve freezer organization. She said the situation was being unfairly criminalized after the fact. Everything she said made the next consequence easier. Judge Sloan began ruling from the bench in short, deliberate lines. He said the conviction changed the legal posture. He said the government had offered substantial proof that Mara personally participated in after-hours removal of preserved sample evidence. He said the audio, access records, discrepancy report, and substitution email formed a coherent picture of concealment rather than confusion. He said the court did not find Mara's explanation credible. Then he said the sentence she had likely feared from the moment the zipper opened. Release is revoked. The defendant is remanded effective immediately. There's always a pause after a line like that. Not because people did not hear it, because they did. Then the movement starts. Mercer reached toward Mara's elbow, but didn't quite touch her. One marshal stepped in from the back wall. Another moved through the side aisle. Mara did not stand right away. She looked at the white tote on the lectern as if it were still somehow manageable, still something that could be explained by another affidavit, another expert, another motion filed before midnight. But the room was past that. When she rose, she had the rigid posture of someone trying to hold on to control through posture alone. The marshal told her to place her hands behind her back. The gallery stayed perfectly still. Then came the sound, a small, metallic click. Then a second. That sound always changes the meaning of the day. Until then, it is argument, paper, voice, theory. After that, it is transport, intake, inventory, detention. And the cuffs were not the end of Mara Ellison's problems. They were the beginning of a wider one. First, sentencing just got worse. Judges do not separate post-conviction evidence handling from the rest of the case. If Mara was still shaping what outside reviewers could see after a jury convicted her, every argument about remorse, reliability, and medical mission is now weaker than it was 20 minutes earlier. Second, the witness pressure expands overnight. Nadia Romero is no longer just a former quality pharmacist with bad memories of a difficult employer. She is now a witness whose testimony aligns with physical recovery, access logs, and Mara's own recorded instructions. Other employees watching this unfold will understand that the government is still finding fresh obstruction evidence after trial. That changes cooperation math very quickly. Third, the substitute bag problem could generate new charges all by itself. Removal is one thing. Replacement with fake retains is another. That is not merely failure to preserve. That starts sounding like fabrication of evidentiary material, false records, maybe even new obstruction exposure for whoever printed the replacement labels and staged the freezer shelf. Fourth, the medical fallout gets uglier from here. Retained samples exist for a reason. If the challenged oncology lots were the ones most likely to show dilution, their disappearance invites a brutal inference about what the originals would have revealed. Civil lawyers, regulators, insurers, and hospital partners will all understand that immediately. And detention is not abstract. Mara would be processed that evening. Jewelry off, property inventoried, medical screening, holding cell. Her lawyers will file emergency motions because they have to. But appellate courts are not eager to second-guess a detention ruling when a judge has just found, on the detailed record, that the defendant touched preserved evidence after conviction and tried to leave cleaner-looking stand-ins behind. What she likely thought would happen is also clear enough. She probably thought this hearing would buy time. Time to organize sentencing papers. Time to keep staff aligned. Time to preserve the polished narrative of a busy medical executive overwhelmed by bureaucracy. Instead, the government pulled that narrative open with a white tote, an audio clip, and the oldest courtroom lesson there is. Once the physical evidence starts matching the bad explanation, the floor goes fast. By the time the marshals led her through the side door, the tote was still sitting open under the courtroom lights. White vinyl, gray zipper, empty sleeves. One blinking logger with a dead battery almost gone. That was enough to take away her last ordinary night of freedom. And it may not be done causing damage yet. So let me ask you, once the judge heard Mara say no chain forms on this one and saw what was inside that white pharmacy tote, was immediate remand the only realistic outcome?